Hello and welcome. We will get started in just 1 minute to allow everyone to zoom up. All right, well, hello. My name is Lauren Van Schulfgaard. I am Coach de Pueblo and the director of the Tribal Legal Development Clinic here at UCLA School of Law. And it is my honor to welcome you to the final event of the Native Nations Law and Policy Center's Fall 2021 Speaker Series. Today, we are featuring the Ascension of Tribal Cultural Property Law, which is super cool and very focused on tribes and the ways in which they are innovating in this incredibly important area. And just so happens to be thematically relevant in light of all of the stuff happening over at the White House Tribal Nation Summit. Before we begin, I would like to start with a land acknowledgement. The UCLA School of Law would like to acknowledge the Gabrielino Tongva people as the traditional land caretakers of Tovangnar, also known as the Los Angeles Basin and Southern Channel Islands. As a land grant institution, we pay our respects to the Hugnukvatum, or ancestors, Ahiharum, elders, and the Ayuhinkanem, our relations and relatives, past, present, and emerging. Today, we are honored to hear a very incredible panel of Indigenous scholars. We will be starting with Professor Angela Riley, who is a member of the Citizen Potawatomi Nation. She is a professor of law and director of our Native Nations Law and Policy Center, and also serves as Chief Justice for the Supreme Court of the Citizen Potawatomi Nation. We have Kristen Carpenter, who is the Council Tree Professor of Law at the University of Colorado and served as a member of the United Nations Expert Mechanism on the Rights of Indigenous Peoples from 2017 to 2021. Then we will have Trevor Reed, who is an Associate Professor of Law at Arizona State University's Sandra Day O'Connor College of Law. And finally, Professor Rebecca Sosi, who is of Yaqui descent and is a Regents Professor of Law and faculty co-chair for the Indigenous Peoples Law and Policy Program at the James E. Rogers College of Law at the University of Arizona. I am extremely excited for this panel, and it is my honor to now turn it over to Professor Riley.
Hi, everyone. I hope you can see my screen. I'm just getting my system all set up here.
It looks good.
Okay, thank you, Lauren. Well, bonjour, everyone. Hello, it's so nice to be here. Thank you for joining us today. I have to say I'm really beyond excited about this panel because of the opportunity to, one, tell you a little bit about the Ascension of Indigenous Cultural Property Law, which is the name of a paper that I've been working on for the last couple of years, and I've had the opportunity to share with my co-panelists. So it's sort of a jumping off point for our conversation today. But I'm also just so excited to be in conversation with these amazing scholars and friends. I'm excited for what's going to happen in the next hour. I wanted to just start by saying a couple of words of thank you. I don't know if they're actually on the call, but Emily Kent and Rachel Sweetnam are my research assistants. They did an enormous amount of work to pull this material together. So I want to acknowledge them. I want to acknowledge the National Indian Law Library at the Native American Rights Fund and the Chief Librarian, Ann Luck, who was incredibly supportive and helpful to me in this project, and also Sue Noe, who's also at NARF. So I had, as of a few years ago, I've been working in tribal law for quite some time and cultural property law for quite some time. But until a few years ago, I don't think it was University of Montana Law School Symposium was the first time I think I ever heard the term data sovereignty when Rebecca Sosi, who is one of my co-panelists today, gave this incredible talk. And data sovereignty has made its way into my paper and into my presentation today. So I'm so excited to hear Professor Sosi talk more about data sovereignty. I've been, sort of hand in hand as a friend, and not so much as a colleague, but as a friend of Professor Kristen Carpenter over the last couple of years as she's worked on the expert mechanism and spent an enormous amount of time and commitment to effectuate the eventual repatriation of the Masakova. And she is going to be talking about that today, which I'm delighted to hear and have her share that. And Trevor Reed, who is one of our newer colleagues in the field, who I've had the pleasure of getting to know over the past couple of years, who's doing some really incredible work at the intersection of cultural and intellectual property and tribal law, and particularly focused on the Hopi. So I'm delighted to be in conversation with him as well. I'm sharing my screen. Hopefully you guys can see this. I wanted to just start by saying a little bit about the paper, and I don't want to take up too much time because I want most of this time to be devoted to my panelists, but I wanted to give you a sense of what it is that I was doing and how I got here. So first of all, the question of why are we focusing on tribal law or Indigenous law in this panel? A lot of us have been working in tribal law for many, many years. Professor Sosi has been a tribal court judge probably for well more than a decade. I know Professor Carpenter is now a judge as well, and so am I. And Trevor, of course, deeply engaged with his own community. We've all been working in tribal law for a long time, and it's really incredible to see its ascension in various aspects of protecting tribes' cultural and intellectual property, both on the ground at the tribal level, but also really emanating out and influencing law externally in national and international conversations. In the paper, I go into more detail, but for me personally, the reasons that I think it's so important to explicate tribal law on these issues is, one is it really animates tribal sovereignty and Indigenous peoples' rights to self-determination as protected under international human rights law, including the UN Declaration. The second reason may be even more pronounced because it reflects Indigenous lifeways. I think as many people who are probably observing this panel are aware, Western intellectual property law doesn't have the mechanisms in place to protect Indigenous peoples' cultural and intellectual property. And the challenge of how to do that is one of the questions that's being taken up by the World Intellectual Property Organization, among others, to sort of figure out what is the best way forward with protecting tribal traditional knowledge. And so from my own perspective, really engaging this question at the tribal level and asking tribes themselves, what are they doing? What do they want to protect? How are they working in the field is sort of the starting point. And so I think tribal law is able to really give life to tribal lifeways and belief systems in ways that Western intellectual property law just has been incapable of doing. And then third is to influence external systems and to set a model for the protection of traditional knowledge in a world where we keep being told by external forces that it's just impossible or infeasible to protect Indigenous people's knowledge. And so for all of those reasons, I focused on a tribal law project. This project really started a long time ago, more than 15 years ago. I wrote an article, one of the first articles I ever wrote as a professor, called Straight Stealing Towards an Indigenous System of Cultural Property Protection. And in that project, which is, again, more than a decade ago, I attempted to do the first comprehensive survey of what the tribes in the United States were doing to protect their cultural and intellectual property. In doing so, I limited that research project to federally recognized tribes in the lower 48. I expanded out from that for this current project and included the Alaskan Native villages as well. At the time, there were 351 federally recognized tribes. And what I did in that survey, which again, is not an empirical project in sort of the methodologically in the quantitative sense, I really just did a lot of researching and counting and cataloging and trying to find, did tribes have official websites? Did they have cultural resource protection programs? And did they have cultural preservation codes? So in part inspired by my work with the Indigenous Caucus and Native American Rights Fund on the WIPO project to protect traditional knowledge, I decided to undertake the research again and to try to replicate the study in some ways, although not identically, and see what it is that tribes are now doing today. I expanded the search to the Alaska Native villages. So there were 574 tribes in the pool, and sought, for the most part, the same categories of information, and again, used a lot of the resources that were available online, also through libraries, and of course through NIL, which was incredibly helpful. So I thought I would just give you kind of a snapshot of the comparative findings, and I have a couple of graphs to show as well. So one thing, I mean, you'll just see across the board the increase in every category. This little snapshot here doesn't really kind of give you the granular detail that you need. If you want to see that, you can get that in the paper. The paper is going to be published by the Michigan Law Review in the next year, and it's in draft form right now. So I'm still working out the kinks. But just to give you a snapshot in terms of tribal websites, 2005 we had 193, now 351. So obviously significant increase. And the tribal websites were relevant because that was one of the places that's the first place we looked, really, to try to see if tribes were publishing their own tribal codes and or if they had cultural resource protection programs. The resource protection programs jumped from 62 to 201. Cultural preservation codes, I only found 27 in 2005, and I found 134 this time. Intellectual property codes, so codes that specifically go to protect IP in the Western sense, intangible knowledge, traditional knowledge, medicinal knowledge, patent, trademark. I had a very capacious set of search terms. I found none in 2005 and 48 in 2020 in my most recent search. And then also expanding the search to include the phrase data sovereignty, as Professor Sosi will speak about, and also IRB protocols, so internal review board protocols that tribes have, setting up their own rules and procedures if you want to do research with or about the tribes. I didn't search for this in 2005. It wasn't even on my radar screen. In 2020, I found 49 tribes that fell within this category. This is just an overview comparison of those categories in graph form, so you can see the jump from the blue to the orange. And this is the 2020 finding snapshot. So you can see among the tribal codes, so this is a reflection of the tribal codes, cultural preservation is a catch-all category. So the cultural preservation could include any sort of subcategory. We see a lot of protection at the tribal level for burial sites and to effectuate repatriation. Some of these explicitly referencing the Native American Graves Protection and Repatriation Act, or NAGPRA, some not. Sacred and ceremonial sites is a point of key importance and interest to tribes, not surprisingly. Expressly protecting intangible property is now being included more and more in tribal codes, as well as data sovereignty. I just wanted to give you, these are anonymized samples, but I just wanted to give you 3 quick anonymized samples of things that tribes are doing. Again, keeping in mind that I found, into the hundreds of tribes that were protecting this type of knowledge. This is an example of a code that is in some ways akin to, or at least referencing by implication, the Indian Arts and Crafts Act. You can see here that the tribe is attempting to protect, allow a pathway for tribal members who create traditional products to identify them as affiliated with the tribe. So it sort of works almost like a consumer mark, somewhat like a trademark. The next one is a tribe that does a couple of things that are of interest. I didn't expressly go through to find references to the UN Declaration on the Rights of Indigenous Peoples in this research project, but we have gone through and done that work in our Tribal Implementation Toolkit, which is available on our website if you're interested. We really did a deep dive to figure out which tribes were referencing the UN Declaration or implementing it. So I encourage you to take a look at that. Maybe Lauren could put a link to that in the chat if she gets a moment. But this code does a couple of things. One, references the UN Declaration. Another thing that I focused on, I saw in a lot of tribal codes, was protecting intellectual and cultural property for future generations. A lot of reference to ancestors, past and present and emerging, protections for all kinds of intangible property, including oral traditions, medicinal knowledge, even language systems, etc. And the final one, here's another example that just shows a tribe that is kind of alluding to a copyright type of protection, where the tribe puts into place that the tribe holds specific designs themselves in a communal way, sacred as gifts from the creator, and then allows some of those designs to be selectively employed or used by tribal members, again, kind of with reference to a copyright type structure. So those are just three of the examples I found. When I mentioned the number, the overall number, which is well into the hundreds, that's the number of tribes that we included, meaning that's the number of tribes that have these protections in place. But one tribe, for example, could have 30 or 40 or even 50 codes that fall within the cultural preservation realm. So what I'm actually seeing is an incredibly robust body of law that's being created at the tribal level to protect traditional knowledge. And it's exciting to see. It's incredibly powerful. Some of the tribal codes are written in their native languages with translations in footnotes. There's a great deal of emphasis on sustainability and on protection of the planet and the culture for the future. So it's really heartening to see tribes taking the lead in this way. So with that, I'm going to stop sharing my screen, and I'm going to now conclude my presentation so that we can hear from our other panelists. And I'm delighted now to turn it over to my friend and colleague, Professor Kristen Carpenter.
Thank you, Angela. What a wonderful presentation. Congratulations on the article and the project, which are so exciting. And I know that everybody is looking forward to it coming out in print so we can all get the full version. But really, between the claims you're staking out about the importance of tribal law and cultural property and the really rigorous methodology you undertook, I think this is a very important contribution to the literature in the field. I'm also glad to be here with Rebecca Sosi and Trevor Reed, and all of us, I think, sort of comprise the subfield of Indigenous peoples' cultural property law. So it's really great to be with you. I'm going to go ahead and share my screen. Okay, are the slides coming through okay? Terrific, thank you. So at Angela's invitation, I thought I would talk about the laws, customs, and traditions of Indigenous peoples in cultural rights diplomacy focused on the international arena, where I've been working for the last number of years. And I'll consider those themes generally and then look more specifically at the case of the Yaqui people and the Masakova as an example. So I think one of the starting points, one of the questions I'd like to consider is whose law matters internationally in cultural property protection. And the first answer is that nation states law matters. And as in many cases in international law, this is a body of law that's created largely through agreement between nation states who are member states of the United Nations. And the leading treaty in this realm concerning cultural property is this Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property, a real mouthful, that came into force in 1970, which the United States and many other states are parties to. And just to point out a couple of critical elements, this convention is meant to both prohibit and remedy the illicit trafficking of cultural property among the entire world, but it reveals its state-centric nature in several ways. Not only are states the parties to the convention, but states are the ones who determine whether cultural property has been taken illicitly from its country or its party of origin. So illicitly, illegally, that term in Article 2, Article 13, and so many others really is based on state law, by which we mean the laws of France or England or the United States or whomever. And that's a really important threshold because the convention also provides for restitution of cultural property that has been illicitly exported. And again, the reference point is to the national laws of states. There is this more flexible article near the end, Article 15, which I'll come back to at the end of the discussion, where state parties, if they want to, may engage in repatriation, even in circumstances where there hasn't been the illicit transfer, but they're not required to. This is more of a voluntary, discretionary provision. So on the one hand, this convention is not exceptional in terms of international law. It focuses on states, but it's somewhat limited, at least when it comes to Indigenous peoples, because it requires them to be represented by their nation states in international law and diplomacy. And sometimes this works out okay. And I think one of the best things the Trump administration did during its 4 years in office was actually to negotiate with Finland regarding the return of Indigenous peoples' cultural objects that were taken from Mesa Verde. But on the other hand, every time I look at this picture, I think, what's missing from this image? And what's missing are Indigenous peoples who didn't have a seat at the table when these state-to-state negotiations were going on. And here in the United States, fortunately, we have NAGPRA, which ensures that when the national government comes into possession of Indigenous peoples' human remains or cultural patrimony, there will be a process of repatriation. But when Indigenous peoples aren't at the table, it's possible that some of their own meanings, their own customs, their own traditions about cultural property won't be explicated. And in other countries, and in fact, most countries around the world, there is no NAGPRA. And so if the nation state makes a claim for the return of human remains or cultural patrimony, there is no obligation to then return it to the Indigenous peoples from whom it originated. And so there's a gap, as you might expect, in the international law of cultural property when it comes to Indigenous peoples. One way to address that gap here and in many other realms, and Professor Riley mentioned this, is through the UN Declaration on the Rights of Indigenous Peoples, which was adopted by the General Assembly in 2007. And just to point out a couple of provisions that are relevant to our conversation, Article 11, which is one of the repatriation articles, talks about the requirement to provide restitution of cultural, religious, spiritual property taken without free, prior, and informed consent, or in violation of their laws, traditions, and customs. So this is a different standard than is the standard under the UNESCO Convention, which talks about the laws of nation states. The Declaration brings into the equation, brings into international law and diplomacy, the whole subject matter that Professor Riley has studied in her article. That is, what are Indigenous people's own laws when it comes to these items? And secondarily, that states have an obligation to provide repatriation according to these standards, and that this is all in support of Indigenous people's rights to culture. I had the opportunity with some amazing leaders from the Yaqui people in both Arizona and Sonora over the last number of years to apply the UN Declaration on the Rights of Indigenous Peoples along with the UNESCO Convention in a very important matter involving cultural patrimony. And this is, of course, a very long story, but I'll have to share the short version, which is that in the 1930s, when the Yaqui people were over 1,700 kilometers away from their homeland, they had been conscripted to a military garrison during the wars between Mexico and the Yaqui people. A sacred item, a masakova, which is a ceremonial deer head of the Yaqui people, was removed from the community. And it was most immediately removed by two anthropologists from a place where the Yaqui people were in residence at the time. And the description of that is often contested, whether they were in prison, they were in residence, but in any event, they were able to go home for the most part following the end of the Yaqui Wars. But this was not the case in the 1930s when they were in fact in Tlaxcala. In 2003, Andrea Carmen, who's a Yaqui human rights activist, happened to be at a museum in Sweden when she saw the Masakova, this consecrated deer head, and she knew immediately that it wasn't appropriately there, that it was a ceremonial religious object. It belongs to a certain society, the Kalencias. She went home and reported this to her communities, who immediately, and you can see a letter on the left, who immediately started to correspond with the Swedish Museum asking for repatriation. What happened next is perhaps unsurprising. The Swedish government and the museum system that holds the Masakova is somewhat akin to our Smithsonian. It's the National Museum System of Sweden. And the Swedish government said, pursuant to Swedish law and the UNESCO convention, this wasn't an illicit acquisition, that it was legal to have acquired the Masakova under Swedish law. They believed it was either by gift or by donation, and that there was nothing in Mexican law that clearly made this illegal either. And so therefore there was no ground for return. The Yaqui people did not give up, and through many diplomatic meetings, they formed alliances with the Sami people of Sweden. They reached out to the national governments of every state involved and continued to push for the return of the Masakova. When I became involved, and I know I only have a couple of minutes, so I'll wrap this up quickly, I was serving on the United Nations Expert Mechanism on the Rights of Indigenous Peoples, which is one of the 3 UN mechanisms devoted to Indigenous peoples' rights. And we had a new mandate at that time to help states and Indigenous peoples realize the aims of the declaration. So the Yaqui people wrote a request to us and asked us to help them with the Masakova repatriation pursuant to those provisions of the declaration that I just mentioned. This is a fuzzy picture, but this is us in Geneva in a plenary session of the MRIP, and you can see Andrea Carmen on the left, as well as Indigenous ceremonial leaders from Brazil and elsewhere focused on the issue of cultural patrimony a few years ago. The real direct connection with Professor Riley's work is that after either 10 years of stalemate or maybe almost 100 years of stalemate, what changed minds and brought the parties together in the Masakova matter was the Yaqui people's insistence on the relevance of their laws, customs, and traditions regarding the Masakova. In every single meeting, and here they are meeting in Sonora, they formed a cross-border Masakova committee to bring these claims forward, and they did so informed by traditional law. And what they kept repeating was that a consecrated Masakova, which this one was, could not be purchased, gifted, or otherwise alienated under Yaqui law. And nobody could possess it except for somebody who was a member of the Kalencias, the relevant society. And women could not be members of the Kalencias. So everything that had been reported by the museum as showing the legitimacy, the licit quality of the transfer, didn't add up, it didn't measure up to the standards of Yaqui law. And if you looked at Yaqui law as seriously as Swedish law or international law, you would see that there was, in fact, an illicit transfer here. I won't go through the detailed statement. It's in Professor Riley's article, as well as the MRIP technical advice note. But the Yaqui people, by recording some of the oral testimony, produced a very detailed statement of their law on this point. And once they presented it in that context, it really helped to, I think, bring the Swedish government to the table, because the Swedish government wanted to have its laws respected. And there are certain obligations that museums, national museums, have to abide by when it comes to their collections. They can't just, deaccession to anybody. They have certain of their own trust responsibilities and so on. So the idea that there was law on both sides really helped to bring the parties to the table. After several years of diplomatic efforts that I don't have time to discuss, we all did come to the table in Vancouver in 2020. And we actually reached an agreement to repatriate the Masakova pursuant to both that flexible article under the UNESCO Convention and the UN Declaration's Article 12. And the agreement explicitly notes the laws of the Yaqui people on par with the laws of Sweden and also the international law, as I mentioned. I think this opens the door, hopefully, for many of the examples Professor Riley highlighted to be applied not only in tribal and US settings, but in international law as well. We hope to see the evolution of a mechanism internationally so that each Indigenous people won't have to approach each state in a one-off sort of way, that we can consolidate these claims and develop some institutional knowledge under the declaration. And just to finish, I'll say here's Chairman Yucapicio from the Yaqui people. Because of COVID, the actual repatriation of the Masakova has not happened yet. That agreement in principle still stands, but the parties are working through the logistics to make that happen. And I think it's telling and powerful that the chairman invokes the Yaqui spiritual laws together with this knowledge that the Masakova will come home eventually. With that, I will conclude. Thank you.
All right, thank you so much, Professor Carpenter, and thank you, Professor Riley, for this wonderful paper and also the invitation to be able to share this space with three of my heroes, people that brought me into this field. So thank you so much. I'm going to go ahead and share my screen. Let's see, here we go. See, make sure I share that correctly. Okay. So one of the things I just wanted to say at the outset is that I think Professor Riley's article comes at a really critical time in the development of Indigenous law, protecting and defending intangible culture, just like it does with tangible culture. And I think it's amazing to see just how much this area has grown in the last 15 years. I think Professor Riley shows just how thoughtful tribal governments have been about designing and implementing their cultural rights laws. You know, tribes are drawing on their own ontologies to design these cultural protections, not just rubber stamping federal cultural resources laws or IP laws. And this work is happening in tribal legal codes. It's not necessarily happening in tribal courts or ceremonial spaces. Tribes are doing this incredibly challenging work of converting elements of their own legal systems into formats that settlers can and should understand. And I say it's incredibly difficult because these codes are codifying not only rules, but ways of life, making connections between phenomena that settler lawmakers and judges haven't been able to grasp. So I think it's a fantastic and remarkable piece, and it shows all of these elements. I think one of the important things that comes out of reading Professor Riley's article is she makes a strong case for the legitimacy of tribal cultural rights laws. And I would argue that Congress now must act to officially recognize those laws and create federal rights of action to enforce them and restore tribal jurisdiction over cultural matters, whether they involve members or non-members. So to illustrate this, I want to start with an example that I've been working with, a case study from the Hopi tribe. So I've used this example a few times before, and some of you may be familiar with it, but I've been working a lot with a set of recordings that Laura Bolton, this woman, made when she traveled to Hopi lands in 1940. As part of her travels, she had made a deal with Victor Records in late 1939 to release an album of Hopi ceremonial songs and songs from other tribes. So in 1940, she traveled to my homeland and began recording with some of our tribal leaders. And there she worked with a man named Dan Kutsangwa, Thomas Banakya, and David Mananya, and recorded 16 songs at my village, and then continued on to other villages, recording 121 songs altogether, then went on to Arizona, New Mexico, other parts of Arizona, New Mexico, and California. Now, as part of this, Bolton had, of course, agreed to release an album, and that's what she did in 1941 after she returned to New York. She released this album, Indian Music of the Southwest, and she actually re-released it in the 1950s, and it sold over 5,000 copies through 1986, and probably many thousand more since then. Ultimately, she transferred her rights to all of these recordings that she made, roughly 30,000 of them, to Columbia University in exchange for an annuity and a professorship worth approximately $1.3 million in today's dollars. Now, what I think is critically important here is that the Hopi song she chose to release on this album, it wasn't just an interesting tune. It was a restricted ceremonial song that's not allowed to be performed outside of ceremonial authority under our traditional laws. Bolton, however, decided to unilaterally distribute it to the public and to make a profit off of it. You know, from a strictly copyright standpoint, that might not be a problem. Copyright's there to catalyze distribution of culture by rewarding authors with this exclusive right to reproduce and distribute things. Under today's federal copyright laws, Bolton might even be considered a joint copyright holder in these kinds of recordings, free to use the recordings how she chooses. And even if she wasn't a copyright holder, there are exceptions like fair use or defenses like latches that might give her and her label some leeway to exploit the recording. And of course, this all presumes that tribal songs, indigenous songs, are just music, they're just art, they're expressions, they're just social signifiers that could get transacted. They're aesthetic objects, in other words, with no real material effects on the world. And frankly, I think that's why we have tribal cultural rights laws, because it's never been that simple. Hopi ceremonial song recordings are different from a typical music album. There's a different creative process. Creation of Hopi song is interconnected with agricultural production, with our territorial sovereignty, and the effects are much different. If done with a good heart, according to local protocols, they can have positive effects on our territory, on the environment, on our people, and they establish authority within our territories and catalyze the creation of new songs. If they're used inappropriately, they can cause harm to people. They can cause harm to our environment and our relations with territory. So I think appropriation of these materials, violation of our local laws and protocols, they not only disrupt the creative environment, they can also have negative effects on our people and on our sovereignty. So Laura Bolton's collections, of course, are just a drop in the bucket, right? These are just rough numbers of indigenous or local communities' cultural materials that are held by institutions in the US, just a smattering of a few of them. We can presume that most, if not all, contain creative expression, traditional knowledge, identifying marks that would be protected by tribal cultural or intellectual property laws, or protocols or standards of care. And we also know that many of these were collected in violation of tribal cultural rights laws, the kinds that Professor Riley has just documented for us and aggregated. Sometimes this happened through unconsented or unethical research practices, bootleg recordings, looting, grave robbing, or sometimes they were just acquired from somebody in the community that didn't have the authority to transfer these kinds of intellectual properties. And we also know that most institutions abide by copyright and other federal IP laws and state IP laws, but most institutions don't necessarily adhere to tribal intellectual property laws or tribal cultural rights laws. And I think Professor Riley makes really clear in this article that protection of indigenous culture is often stifled because of mismatches between indigenous cultural rights laws and federal IP or cultural rights laws. Take, for example, this Hopi 1994 law, which codified existing law vesting ownership of media like the kinds that Laura Bolton recorded, which contain esoteric ritual, ceremony, religious knowledge, and assigned those rights to Hopi people collectively. And this was designed, from what I understand, specifically for situations like this one involving Laura Bolton, opening up the possibility that the tribe could regulate these recordings, or if needed, they could exclude non-members from using these kinds of materials. But I think, as Professor Riley rightly points out in the article, enforcing tribal IP laws against non-members presents a really challenging question. Other countries, like Professor Carpenter just mentioned, are following the United Nations Declaration on the Rights of Indigenous Peoples. But in the US, there really only seems like 4 pathways through which tribes can actually enforce their IP laws, like this Hopi law, against non-members like Bolton and the institutions that exist off tribal lands that she did business with. So, I mean, of course, when federal law perfectly aligns with tribal IP law, that's great, and tribes can enforce those rights. But that's really not often the case. Tribes can sometimes directly enforce their tribal laws when we have a federal common law remedy or maybe a federal statute like NAGPRA that gives the chance to reclaim materials with reference to tribal law. And, tribal law provides the primary right, and then the federal law provides the remedy. Tribes can sometimes also enforce their IP laws against settlers entering tribal lands. But as I mentioned, most of these institutions are located off tribal lands and outside of tribes' borders, and don't necessarily have those connections or privity with tribes that might be necessary to enforce tribal IP rights. On the bright side, though, many institutions are taking private action. They're creating institutional policies that recognize tribal IP rights. And I think this is where Professor Riley's research will have an almost immediate impact on these institutions while we wait for Congress to take more action. For example, institutions like the Society for American Archivists, representing several thousand institutional and corporate archives, the Association for College Research Libraries, the American Philosophical Society, the Smithsonian Center for Folklife. All of these have adopted or endorsed sets of protocols that, to different degrees, allow for enforcement of tribal laws, protocols, and standards of care. Some explicitly recognize tribal IP rights, or maybe they give deference to tribal authority in decision-making over these kinds of things. Some acknowledge that violating tribal IP rights actually causes harm and should be avoided. And some even provide remedies, right? They require consultation over who can access materials. Sometimes they require repatriation. Now that tribes have codified their laws, institutions who are members of these organizations can now be held accountable by tribes, because we know that their central entities have already adopted these protocols, have endorsed them. And now we can say, look, we have these laws, why aren't you following them? Or at least, make arrangements to make sure that we have input in that decision-making process. I'll leave it there. And before I conclude, I want to thank the Hopi Cultural Preservation Office, and in particular, Stuart Koyamtiwa, who helped me with this research and has been spearheading so much of this work at the Hopi tribe. And I will go ahead and pass the baton over to Professor Sosi.
Thank you so much. And good afternoon to everybody. I want to say a huge happy greeting to all of you. Angela, thank you for this amazing paper, which I so much enjoyed reading, and it really is a pinnacle in terms of your important work over many, many years. Lauren, your introduction was beautiful, and thank you for the land acknowledgement. Kristen, your work with MRIP was transformative, and on behalf of all the people that will be touched by the healing that you helped to bring about across the borders for UMA people, I just thank you from the bottom of my heart for that. And they say that every time those items go home, there is a healing of many things that have been so hard in the past. So thank you. And Trevor, what can I say? I am so grateful that you are at ASU and stewarding that wonderful program. Thank you for your work and your research. And to all my students who are listening today, thank you so much for being part of my federal Indian law cohort this semester. I know we have a lot of people in the audience who are experts on many things, and there's some former students and alums, and I just say greetings to all of you as well. So my job on the panel is to talk specifically about data sovereignty. And I want to thank Stephanie Carroll, who's my colleague at the University of Arizona, who's really done some amazing work in this area, as well as my other University of Arizona Native faculty colleagues. So I am honored to work with them on many, many of these issues. And I've seen just since 2016, when we started to talk about this, since 2016, there has been an active and vibrant engagement across borders. It's global, it's national, around the construct of Indigenous data sovereignty, which of course is inclusive of the recognized tribal governments here in the United States, but it's transcendent because it deals with the rights of Indigenous peoples. And that's why the international human rights framework and the US domestic framework both have to be accountable to Indigenous peoples' law, whether that is written and codified or whether it is not written and codified. And I realize that there are issues in terms of the accessibility and availability of that. That may be something that comes up in the question and answer period. So within Angela's extraordinary paper, and you really did the heavy lifting on the research. I didn't know that there were 49 tribes who actually had this construct within their codes until I read your paper. And you also pointed to different strands of what in my prior work I framed as epistemic injustice, and all of the scholars on this panel have been talking about that, the gaps in terminology. Angela, you mentioned that in 2005, when you did your first study, the term data sovereignty didn't exist, right? It didn't exist. Today, the terminology does exist. The harms that you are mentioning, Kristen, in terms of the wrongfully appropriated item in Sweden, and Trevor, that you are mentioning in terms of the sound recordings that embody all of this knowledge, the cultural harms that accrued to the people, there was no category to account for those harms, right? You couldn't account for that within the domestic law. So that idea of cultural harm is another important contribution. So epistemic injustice occurs when the ways of knowing of a people are obscured by the categories, say in this case of law, generated by other people and other cultures that cannot account for the harms or the understandings of Native people. And so, Angela, in your article, you illustrate that with case study after case study after case study. And it is absolutely brilliant and breathtaking to have that documented in a place. So that is a contribution. So what are we talking about with Indigenous data sovereignty? The idea of Indigenous data sovereignty is that the information about tribes and tribal cultures and tribal lands and tribal health and tribal environment, all of that information is really emblematic of the tribe and the individual members of the tribe in many cases that gave that information or data. But we have these vast data sets globally and nationally. And today we are in a world of digital technology, which enables the researchers to link up to all of those data sets and analyze data and come up with conclusions. So the process really can be devoid of any tribal participation because it often happens in ways that are invisible to tribal governments. And so it seems to me very important to see what tribal governments say about what they consider to be tribal data and what the conditions are to access that data. And I'll just offer some brief comments in light of the discussion in Angela's paper. So Angela discusses a case that is very difficult in the politics of Arizona, the case involving the Havasupai tribes lawsuit against Arizona State University in 2004. And that case was ultimately settled, but it was for the wrongful use of actual physical samples that were taken for a diabetes study and then used by other researchers through this practice of data sharing for secondary uses that were never authorized and were actually antithetical to tribal belief systems, as well as sort of responsible for these cultural forms of harm that were absolutely horrific in terms of the way that the tribe understood that. So all of that came into a lawsuit, but there were not legal categories to understand, was there a tribal collective interest in genetic data and the information that could be extracted from that? Or was that the product of individual members who voluntarily, quote unquote, consented to give that to the researchers, in which case all of the principles of US law about the researcher and subject would apply and not the tribal law. So that was a very difficult case to navigate, but it led to many positive outcomes because it got into the public eye the fact that tribal governments had different norms for dealing with genetic research and with the responsible conduct that should be effectuated. And so following that, there was a pretty intensive effort to tailor the NIH policies around tribal data to account for the harms in that case. And this work is absolutely incomplete, and it cannot be completed without reference to Indigenous law. And those laws are going to look different for each particular tribal government in many cases. So that's the other qualification. I've had calls from people saying, well, what happened in the Havasupai case, and should we make a tribal law about that and just use that model of what they believed in? And I often say it really depends on how a particular tribal government conceptualizes those issues. And so the important thing is, was there a consent process and a consultation with the tribal government? And so that goes into the area that Trevor was talking about, which in our national policy, we are recrafting our consultation policies to be more substantive, less procedural, more substantive. And in that process, tribal law is going to be very, very important. So before I want to talk briefly, if we have time, and Angela, I think I have probably 2 minutes. So I just want to say 2 things. So I want to draw on the insights that you made in your paper about why tribal law matters. And there are 4 aspects of this that I think are important in the emergent work in data sovereignty. So first of all, tribal law gives you the counterweight to epistemic injustice. The categories that you identified in tribal law are going to be the relevant categories into the future. Secondly, do we have to expand our national policy? For example, should informed consent be constructed around self-determination as a group autonomy interest? To where the people have to consent, and it's not just an individual process. Third, what are the legislative actions that are necessary in the domestic arena? Trevor talked about this category of intellectual property rights and intangible property. Angela and Trevor and Kristen have all been engaged with the work that's happening in WIPO. So you can has to be a synergy between domestic categories and international treaties. And here's a sort of a level of national engagement that needs to happen. And finally, I think that we can see that our domestic law is only improved by incorporating the norms and values of Indigenous peoples here and beyond, because it is a holistic model. So that idea of cultural sustainability elicits the attachment between people, land, and future generations. It's holistic and very powerful, and will make a big difference in terms of the work in the future. So the case studies that I would talk about if I had more time, but I don't, are what is happening specifically in terms of health research and NIH policy and tribal IRBs and tribal biobanks. There are people in the audience who are actually working on this. It is amazing what is happening in Indian country, and I totally welcome questions and comments on that. Environmental, a huge arena for data sovereignty. I'm not as up to speed as I should be, but we obviously just finished the Council Parties 26, as well as had a legendary and transformative moment in national policy with President Biden's statements about incorporating traditional knowledge into US environmental and climate policy and the actions of agencies. So this is a rich area for discussion, both because of the sacred aspect of some TEK. So we want to make sure that tribal protocols are followed, but also because it does open the door to a better future in terms of climate sustainability. And finally, the commodification of data. artificial intelligence, machine learning, huge data sets, the commercial value of that, and how data is taken from tribal members as well as tribes, quite unknown to them within the politics of that process. So those are things that I would talk about if I have time. I don't. I welcome any questions, and thank you again for allowing me to participate on this amazing panel.
Thank you so much, Professor Sosi. And I do want to hear more about all of those things. I know we have questions, but before I turn it over to the audience for Q&A, I just wanted to invite the panelists, just if you have any response that you want to just jump in with 1 or 2 minutes before we do the Q&A, because I just feel like there's so much great information here that we could be in conversation with one another about before we open it up. So I'll just be a professor about it and just call on Professor Carpenter. Do you want to start? Do you have any reactions, Professor Carpenter?
Yes, and thank you all for the amazing presentations. I wanted to pick up on one point that you made, Angela, in the article about the importance of tribal law and its capacity to influence external systems, because of course, tribal law is important in its own right and within tribal jurisdictions. But I think this influence on other systems is also important. And I heard one point from Trevor and one point from Rebecca along those lines that I just wanted to amplify. When Trevor had the model of Hopi intellectual and cultural property, I thought that was so powerful, because for a long time, many of us have been trying to describe why the system and actually the values underlying Western intellectual property law, that is incentivizing innovation through economic and market means, falls short. But I haven't seen such a clear and cogent example, and I'm sure other tribes have other ones, but I love the way you described it in Hopi. And I think that's one of those places where elucidating that information could really help with our critique of what's missing in Western law. And I would encourage others maybe to follow along that intellectual move and sort of, really expose what Trevor has done in the Hopi context. And then Rebecca, when you were just mentioning about the ramifications for data sovereignty on health, on the environment, on human dignity, that reminded me of the indivisibility of human rights and how all of these concepts of cultural rights are so connected to other aspects of Indigenous people's life. And my attachment to the human rights system maybe is informed by that, but I think it describes the overall importance of this work. So thank you.
Thanks so much, Kristen. Trevor and Rebecca, do either of you want to jump in with some responses before we open it up?
I'll just follow up on Kristen's point and invite audience members to weigh in too. I think that point you just made about the indivisibility of human rights is totally important, because as I look at it, there's going to be a need for new governance structures, because the system is siloed right now. You have the political, and you have the social economic, and then you have the cultural, but the issues that we're talking about are transcendent. They cut across that. And so at the interface of Indigenous governance within those structures in a coherent way. So that's what I see as necessary.
Trevor, anything?
I just wanted to follow up on Professor Carpenter's talk about that repatriation work, and in particular, the interactions that generated the really interesting sets of protocols and standards of care, things like that. I think you mentioned there were kind of 6 or 7 different points, kind of elaborating how that particular item needed to be treated, and kind of the way that the folks should go about caring for it, both where it was and then in its process of coming back. And just that dialogic process, I'm curious, how does that fit into the treatment of tribal codes going forward? I mean, a lot of times from a legal perspective, we're trying to interpret the specific texts of a code, but it almost seems like there was kind of an elaboration of Yaqui law in that instance, and I'm really curious to hear a little bit more about that. Should we be treating these tribal codes as just kind of static text, or should we be treating them as kind of a living thing that should be elaborated and kind of a cue to help us to understand really how these Indigenous communities are thinking about their materials?
Well, I just wanted to say one thing, and I don't know, Kristen, if you wanted to respond to that, but I just wanted to take one moment just to thank Rebecca for your incredible article from several years ago now, but articulating the concept of cultural harm, because I think it informs all of this work and all of our work, and it's just a really beautiful and incredibly well thought out articulation of what it means for Indigenous people to be harmed by appropriation, sometimes of tangible and sometimes of intangible property and knowledge. And it's something that's very, very hard to convey from an Indigenous worldview to a non-Indigenous worldview, why it is harm, and how it's experienced at the tribal level. And I think a lot of this work really couldn't have happened without that article that you wrote and without that work. And I think it just, it's really, it's just powerful. I feel like I get, it's very in the weeds and it's in the paper. So eventually, if you want to read about it, but I've been deeply involved with rewriting the repatriation policy at the University of California system over the last couple of years. And one of the key features of the new policy will be to elevate Indigenous knowledge equal or greater to that of quote unquote scientific knowledge. And it's just so critical as we have example after example after example of Indigenous people saying, this is this is true, this is where we're from, or this is who we are, or these are our experiences, constantly get denigrated by Western knowledge until Western science proves that Indigenous peoples were right all along. And it's an experience. I feel like every other day I pick up the New York Times, I see an example of it. So when Indigenous peoples articulate that they do experience cultural harm from things like having the Massacova in a museum, to believe them and to understand what that means for tribal communities to have this property misappropriated. I will stop talking because we have about 12 minutes, but I will turn it over to Lauren, who was going to take charge of the Q&A for us. Lauren.
Oh my gosh, we have a lot going on in the chat. The chat is super fun today. Okay, there's so much. There's two big themes that I see, and so maybe I'll let the panel decide which one they want to tackle. There are a lot of different discussions around genetic information, including the corporatization of genetic material, including agriculture, and I think other areas, both human, animal, and plants, that a lot of tribes claim traditional knowledge over that is now being corporatized. There's a lot of tension there. There is questions around this common theme around we need to balance stakeholders and the premise of copyright as expiring in order to provide it into the public notice. So it's almost like tribes owe something to the world to provide access to their tribal knowledge and shouldn't be allowed to keep it to themselves. And then finally, which goes, I think, to some of Trevor's points, there, it seems like a lot of tribes are going about the work of codification less for their own purposes, because they know orally and within their own systems about what the law is, but to really signal to the world. But that begs the question of enforcement. And I wonder if there are any other systems outside of cultural property that provide a good framework for how tribes might ensure the enforcement of their codes, or if this is something that we need to invent. So 3 big things there, and I invite the panel to latch on to anything that moves you.
Thank you, Lauren. I don't want to call on anyone, but Rebecca, I feel like a lot of the genetic resources stuff might be well suited for you to respond to.
Sure, I'd be happy to offer some thoughts, and I'm afraid to open the chat because I might disengage the Zoom because that's the level of my technological capacity. So I'm just going to go with what you just shared with us, Lauren. So the categories of Indigenous peoples and human subjects research and research on animals, which might be important to Indigenous peoples, or research on plants that might be important to Indigenous peoples. That's an example of a holistic view from an Indigenous perspective. And in Angela's article, the cultural preservation codes, for example, I saw that, where they will elicit that maybe there's a relationship with other than human persons, right? That's part of their moral obligation, is to these very important, sometimes the species are first foods or something, but they're very sacred, like salmon or deer, so there is a relationship. And the same thing with plants and corn, or taro for the Native Hawaiian people. So there are these relationships, and that's the essence of moral respect. And it can be the essence of legal protection under tribal law. So if we just said we want reciprocity in domestic and international systems for these very firmly held cultural views that are really operating at the level of moral and political rights and self-determination, then we would respect those rights. Now, it's hard though, right? Because in human subjects research, what we have is a whole set of standards, but we also have these national initiatives, precision medicine, genomic research. We need to overcome health disparities. We have to study this. We have to have samples, and we're going to protect your interests up to as much as we can, but you have to be part of the evolution forward. So the categories are not static under the research agenda. Plant and animal, we're in that world of genetic modification. So you genetically modify salmon, what do you get? Can you release that into the stream? Will it contaminate? Will it desecrate? Is there a term for desecration under US law in that sense? And the answer is no. With the global treaties, now the NAFTA, in the current equivalent of NAFTA, I'm not sure what they call it. They changed the name, but you know what I mean. So the nation states all get together and they agree on trade. And in a lot of senses, the corporate interest is protected and privileged in that. And Indigenous peoples aren't at the table with those treaties. So it's another episode of what we were just talking about, which is why we have to retool the governance systems.
Wow, thank you so much. Trevor or Kristen, do either of you want to jump in on any of the questions that were thrown out there originally?
I'm happy to jump in on the question. I think it was from Preston that was asking about what about the length of time, the duration of copyright protection versus, what many tribes want to protect. I mean, certainly a lot of the tribes that I've worked with want to protect the materials that are the oldest and protect them the most that they have. They want to safeguard these. They want to safeguard ceremonies or language or other types of representations that are from time immemorial, as you were saying, Preston. I think that's one of the big conflicts between copyright and tribal laws. Not only that, there are also the solutions that have been presented, like state ownership, also don't fit the bill. And I think this makes the case for why tribal laws need to be enforceable, even beyond the boundaries of tribal lands. And I think that's kind of the key, especially in an age where we have the ability to really keep track of laws that are very divergent, right? I think Indigenous IP rights can be tracked and can be enforceable. And I think people can have notice of those. I think the other thing to keep in mind too, though, and kind of a counter, is that tribes also have ways of phasing out materials that in some cases, cultural, intangible or tangible materials are supposed to dissipate over time and sometimes are supposed to be forgotten. And we don't always think about that, but certainly it's not the settler state's job to have us forget those or to leave them open so that they can be destroyed or desecrated, right? But certainly Indigenous laws and Indigenous standards of care and protocols should be in place and should be enforceable to make sure that those materials kind of travel along their life path the way that they're supposed to. Anyway, that would be my partial answer to that.
I'll just say one really brief thing. And I'm not sure which question it's directly responsive to, but we had talked, and I know you wrote about this, Angela, about some of the opportunities, but also challenges of writing down laws that may be customary in nature. And Lauren had mentioned that somebody in the chat had raised, well, what is the purpose here? And often in communities, people know about the traditional values and traditional means of protecting certain things, but it's, you know, a signal to the outside world. And just to offer some additional thoughts on those points, Angela, in our work on cultural property, you know, sometimes we were pushed along the lines that culture is very dynamic, but law is very fixed. And why would we want to fix, you know, things, especially in the culture realm, that often change? But I guess, you know, I've arrived at the point, and I think your research shows this too, where I feel that law is also very dynamic, and it's a dynamic expression of tribal values that can be written, that can be oral, that can be amended, that can be interpreted over time. And so even though there are trade-offs, you know, sometimes when it comes to both writing things down and sharing them with the outside world, I think it's worth considering that the law itself can be as dynamic as these cultures are in navigating changing circumstances, whether that's climate change or developing law and norms around repatriation that may not have existed traditionally. Tribes have to respond to all of these circumstances. And I think it's really wonderful to see them using their lawmaking powers in that regard.
Thank you. Lauren, do you want to jump in?
Well, we have one more question that was seconded, so I'll put it on there, even though we have 2 minutes, which is not fair. But it seems, particularly with the newest justices on the US Supreme Court, that there is a potential for a re-examination of the freedom of religion under US constitutional law, which is, I think, mainstream envisioned from a Christian perspective, but it appears to have potential to revisit Ling and the San Francisco Peaks case. And so we're wondering if the panel has any thoughts on the potential to leverage those arguments to reinforce the tribal cultural property laws that you highlighted today.
Well, I'm going to say one thing, and then I'm going to make Kristen Carpenter answer this question because she's the expert. I'll just say, I remember in 2006 when the first opinion, I believe that Justice Roberts wrote, was the Gonzalez versus O Centro case, which was a Religious Freedom Restoration Act case that involved legitimate religious practitioners who used hallucinogenic tea and had been charged, I believe, by the DEA, and ultimately were able to have a reversal of that under the Religious Freedom Restoration Act. An indigenous religion using what was a prescribed substance under American law. And Roberts writes the opinion, but he goes to great lengths to make sure that people understand he's not writing it because they're indigenous, that there's nothing special about being indigenous, that it's just because the RFRA was violated. But it did occur to me at the time, this exact question that you're asking: how will an increasingly religious court, and of course that's happened more over time, how will they receive religious freedom claims from Native peoples? And now I will ask Kristen to finish the rest of that thought.
Thank you so much. And we really don't have time to do this question justice, although Angela's response set the scene very beautifully. I'm just going to close on an optimistic note, which is that despite other shortcomings, I do believe that many of these justices take to heart that human beings want to have a spiritual life, and to be able to connect with their creator is a quality of what not only we should expect as American citizens, but as human beings. And I do believe that the precedents in Smith and Ling, which are 30 years old, cannot stand in 2021. They violate the First Amendment, they violate human rights, and I think they're going to fall.
Wow, thank you for that. I think with that, we have to conclude, but thank you all so much for your brilliant contributions and for your support and just your vision and inspiration in every way. And thank you to Lauren and Heather for putting this all together. And thank you to our audience for being here. Chimegwech, everyone. Have a great day.